Buenos días. Creo que no hace falta utilizar el micrófono, pero si no me escucharan bien, me lo dicen. En primer lugar, quiero darles las gracias por asistir a este seminario. Quiero dar las gracias de manera muy especial a nuestros dos ponentes, Marina Serrat y Raffaele Petruzzi. Enseguida les presentaré. Y también debo disculpar al profesor Tejerizo, que iba a presidir este acto y a moderar el coloquio, pero acabo de hablar con él, le ha surgido un inconveniente y no va a poder venir. Como saben, este seminario forma parte de la serie de seminarios ECJ Leading Cases, unidos a un blog y a un proyecto de innovación docente de la Universidad Nacional de Educación a Distancia, que coordina la profesora Marina Vargas, aquí presente, y yo mismo. Y la idea en este seminario desde el principio era tratar cuestiones candentes relacionadas con el derecho de la Unión Europea y especialmente las libertades comunitarias, y en el que pudieran participar tanto personas que ya tenían una amplia trayectoria académica como jóvenes investigadores. Y el público también está pensado, desde personas que están trabajando a su tesis doctoral hasta profesionales con una amplia experiencia o profesores con una amplia experiencia o funcionarios, pues pudieran no solo asistir, sino intervenir activamente en el coloquio. De hecho, el primer seminario fue a cargo del profesor Juan Antonio Carrillo, catedrático de Derecho Internacional Público y Privado y antiguo magistrado del Tribunal Europeo de Derechos Humanos. Y en la sesión de hoy nos corresponden los jóvenes investigadores. Y para esto tenemos a Raffaele Petruzzi, que está trabajando en su tesis doctoral en un programa especial de doctorado en la universidad, en la Wirtschaftsuniversität de Viena. Ahora mismo el Instituto de Derecho Tributario Internacional y Austríaco de esta Universidad de Viena creo que es el principal centro de fiscalidad europea e internacional en todo el mundo. Hay otros centros magníficos con másters fantásticos, pero la cantidad de seminarios, actividades y las personas que pasan por allí, desde magistrados del Tribunal de Luxemburgo, magistrados británicos que han planteado las cuestiones prejudiciales, en fin, profesores de toda Europa y de Estados Unidos. Es un centro fantástico que sale adelante gracias al esfuerzo a la sabia dirección del profesor Michael Lang. Y por eso quiero agradecer también al profesor Michael Lang el convenio que tenemos entre el ECJ Seminario y el Instituto de Viena, que nos permite celebrar 3 seminarios compartidos en los que jóvenes investigadores que se han formado en Viena pues vienen a este Instituto de Estudios Fiscales. Tanto Raffaele como Marina han cursado el programa máster, el EM de la Universidad de Viena en Fiscalidad Internacional. Ambos están trabajando en sus tesis doctorales. Marina ha tenido una experiencia profesional en Baker & McKenzie y ahora mismo ha vuelto al ámbito académico. Raffaele también ha tenido una experiencia profesional y ahora está, en fin, dedicado en buena parte al mundo académico. Así que, perdón por esta larga introducción, muchísimas gracias y creo que empezamos por ti, Raffaele. Raffaele will speak in English, then Marina in Spanish, and then... Perdón, yes, sorry.
Spanish, but I don't speak much of it. Okay, so first of all, I want to thank Professor Herrera and the Institute for Estudios Fiscales and the Institute for Austrian and International Tax Law for this opportunity of speaking here in this conference. Today we will talk about the FGI case. It's we probably have the presentation. The FGI case, it was an important case decided in 2010 by the ECJ, and so far it's been the only case on transfer pricing. That's why this has a lot of implication on the transfer pricing rules of the member states. So, okay. Bien. As I was saying, this case is really important for the transfer pricing rules of the European member states, because so far it's been the only one that the ECJ has decided. The agenda for today, in the next 30 minutes, I hope, we will introduce the case, and then we will see what the consequences of the case, the potential consequences of the case are in the transfer pricing rules of the member states in Europe. So this was basically a Belgian case decided, as we said, in 2010, and it was, as we have said, the only one on transfer pricing rules, but there were other two cases so far decided by the ECJ on the arm's length principle, the German Lankhorst-Orts case in 2002, and the UK FinCap law that was on FinCap rules. Basically, the facts of the case were the following. SGI was a Belgian company. They was owned by a Luxembourgish company for 34%, and it was owing a French company for 65%. In 2001, SGI paid management fees to the Luxembourgish company, and it also granted an interest-free loan to the French subsidiary. And the tax authorities, the Belgian tax authorities, were not happy about this situation, especially about the interest-free loan, because in that period, SGI had a lot of debts in its balance sheet, and from the other side, the French company was in a profit-making situation. Therefore, the Belgian tax authorities went to SGI, and they assessed its tax base, denying the deductibility of the management fees from one side, and from the other side, they applied a notional interest on the interest-free loan of 5%. So in total, the assessment was not that big. It was around 50,000 euros. But nevertheless, SGI went in front of the Court of First Instance in Belgium, and the Court of First Instance upheld the decision of the tax authorities, but nevertheless, based on the Belgian transfer pricing rules, but nevertheless asked the court if the Belgian transfer pricing rules, as they were at that time, were in line with EU fundamental freedom. Why? What was the problem? The Belgian legislation on transfer pricing was the following one. Whenever you have exceptional or gratuitous advantages to related companies that are resident in Belgium, then these exceptional or gratuitous advantages would be included in the tax base of the company receiving the advantages. But whenever these exceptional or gratuitous advantages were granted to a related company outside Belgium, then the advantages were taxed in the hands of the granting company. So basically, the Court of First Instance asked to the ECJ if this legislation was compliant with the freedom of establishment and or the free movement of capital. And the ECJ started the analysis from deciding which one was the relevant fundamental freedom, as they always do. They first went into the structure of the legislation, the purpose of the legislation, and they saw that such legislation applies whenever there is a relationship of interdependence between two companies. So this relationship of interdependence could depend from a participation into the capital, a relevant participation into the capital of the two companies, but could depend also on other circumstances, like technical cooperation between the parties. So the ECJ, based on the purpose or the analysis of the purpose of the legislation, could not decide if apply the freedom of establishment or the free movement of capital. Nevertheless, they went into the facts of the case. They saw that there was a relevant participation between the three companies involved. There was a relevant participation into the capital between the three companies involved. Therefore, the court said that this participation was able to give the companies a definitive influence over the decision of the others. So based on the famous Bars case law, the court decided to apply the freedom of establishment. One question might be arise already at this point: what would have been the decision, the outcome of the ECJ at that moment, if the facts of the case were not these ones, and if the companies were related by technical cooperation, not by a participation into the capital, would they still decide that the relevant freedom to apply was the freedom of establishment or the free movement of capital, or other freedoms like freedom of services or freedom of goods? This outcome, of course, would have consequences in cases third companies outside Europe would be involved. The second step of the ECJ was looking if these rules, these Belgian transfer pricing rules, were restricting or discriminating. And they saw that these transfer pricing rules potentially would involve economic double taxation. So even if in Europe we have the convention, the arbitration convention, the ECJ said that the presence of this arbitration convention would not be enough in order to avoid economic double taxation, because the taxpayer would still be bound by financial cost in order to implement this arbitration. And from the other side, the court said that there was a different treatment, tax treatment of companies depending if they were resident in Belgium or not. So these gratuitous advantages were taxed into the hands of the receiving companies in case there was a Belgian to Belgian transaction, but they were taxed into the granting company in case there was a Belgian to foreign transaction. So the court said that these rules were discriminating, were limiting the fundamental freedom of establishment. So at this point, the court went into the analysis of any presence of justification, and they justified these rules, saying that from one side that we're granting the balanced allocation of powers. That was meaning that Belgium, thanks to these rules, would protect its tax base and would have a balanced portion of taxation powers on its multinational companies. From the other side, the other justification was the prevention of tax avoidance. There was meaning that Belgium, thanks to these transfer pricing rules, was avoiding multinational to do some profit shifting out of its country. But they said that these two justifications needed to be taken together. We will see what does they mean in a little bit, what are the consequences of this. And then the court went into proportionality test, and this is a really important test. They applied two tests. They said that these Belgian transfer pricing rules would be compliant, would be proportional, therefore would be okay for European standards if two tests of proportionality would have been respected. First, they would give the opportunity to the taxpayer, without being subject to undue administrative constraints, to provide evidence of commercial justification of a transaction in order to show that this transaction was not an artificial arrangement. And from the other side, the adjustment to the tax base could not be more than what would have been the amount at arm's length. So these were the two proportionality tests that the court applied in order to say that the Belgian transfer pricing rules could have been compliant with EU standards. Now we will see what are the consequences of the case. Before introducing the consequences, we need to talk of the arm's length principle. The arm's length principle basically is what? It's a legal fiction that countries have agreed upon in order to allocate tax base of their multinational between themselves. So basically some countries use the arm's length principle, some other countries use the formal apportionment, some other countries use safe harbors. These two methods are less burdensome. They are justified by the need of having less administrative constraints by the tax administration, and they are easy to manage. But from the other side, the arm's length principle is justified by the fact that it's more compliant with the economic reality of the transaction. Let's see if this is true. Let's suppose that we have a parent company in state A and a subsidiary in state B. Let's imagine that the parent company strongly believes in the business of the subsidiary, even though the subsidiary was always in a loss-making situation since the beginning of its history. But obviously the parent company, since believes in the business of the subsidiary, will not close down the subsidiary, but will still take the subsidiary there, hoping that in the future will make some profits. So because of this, the parent company grants a loan to the subsidiary of 1 billion euros, and in exchange, it charges the subsidiary of 5 million interest per year. Under the economic justification of the transaction, the parent company would be a lot of economic reasons for granting this financing, simply because it clearly believes in the business of the subsidiary, otherwise it would close down the subsidiary. From the other side, if we look at the arm's length principle, country A would assess the tax base of the parent company because it would say that the subsidiary has a high risk of default since it has been always in a loss-making situation. So the interest rate that a third-party financing companies like a bank would apply on such subsidiary would be way higher than 5%. From the other side, country B would assess as well the tax base of the subsidiary. Why? Because they would say no third-party bank would give a loan to a subsidiary that it was always in a loss-making situation. So this is not a loan. This would have been seen as a contribution of capital, as a contribution of equity, and therefore the interest would be not deductible. It would be considered as a payment of dividends. So you can see from this simple example that arm's length principle and the economic reality of the transaction are not the same concept. And we will see in a second what does that mean on what the court said. First, the first question that could be raised now is a non-arm's length transaction has to be considered as tax avoidance? This is important. Is it an important question because countries usually sometimes apply more penalties, higher penalties, whenever a transaction is considered to be tax avoidance. So as we have seen, the arm's length principle is a principle in order to allocate income between different countries. From the other side, the transfer pricing rules are per se anti-avoidance rules. They are aimed at avoiding the profit shifting of the multinational residents in the country, in a specific country. So the court, in this case, said that both justification, the balanced allocation of taxing power and the anti-avoidance justification, should be the ones to apply to the transfer pricing rules. But if we look at the facts of the case, SGI was in a country, Belgium, that was with a tax rate at that moment of 33%. The other company, the subsidiary of SGI, was in France. The tax rate of France was 33.33. So the question is, can the ECJ say that this transaction was justified by tax avoidance reasons? You are shifting profit from one country of 33% of tax rate to another country of 33% of tax rate. Is that really your aim, tax avoidance? If we look at the previous case that we mentioned, the TINCAP law case, the court justified TINCAP rules based only on tax avoidance. In this case, instead, the court added to the tax avoidance justification also the justification of balanced allocation of taxing power. And that might mean that the court doesn't really look at these transfer pricing rules as only being tax avoidance rules, but they are more flexible in judging these rules after this case. The second question that might be raised regards the burden of proof. First question, what has to be proven? The court said that it has to be proven that the transaction has not been entered for tax reasons. Literally, that means that the tax administration can show one just simple tax reason in the transaction in order to apply, in order for the taxpayer not to be free of the transfer pricing rules. But obviously, every transaction naturally has some minimal, even minimal, tax implications. From the other side, in the previous FinCap law, the court said that the taxpayer should show that the transaction has not been entered for tax reasons alone. In this case, it's too easy for the taxpayer to show this evidence because there's always a little bit of economic substance in every transaction. So in my opinion, the court should have said that the taxpayer should show that the transaction has not been entered mainly for tax reasons, but the court didn't say that. The second question is an irrelevant question, and is a non-arm's length amount necessary and acceptable? I mean, we have said that a transfer pricing rule cannot punish the taxpayer more than what is the arm's length amount. But the court didn't say if a non-arm's length amount can be still punished. The court said the taxpayer has to prove any commercial justification. And as we have said before, as we have seen in the previous example, it is the arm's length principle and the economic justification, the commercial justification of the transaction are two different concepts. So can we still say that the taxpayer is allowed to justify a non-arm's length amount whenever he's able to provide evidence of the commercial justification of the transaction? This is something that, if we take into account the tax avoidance nature of this rule, maybe the subjective intent of the taxpayer is relevant, and therefore the taxpayer should be able to show that the arrangement is not artificial. If we take instead into account and give more relevance to the justification of balance allocation of taxing power, the arm's length principle should be the relevant ones all the time. Another possible question is, when does the possibility of providing commercial justification of the transaction has to be given? The court said whenever there is a suspicion that a transaction goes behind the arm's length principle. So in this case, the court is really specific. Whenever there is a suspicion of non-arm's length amount, you have to give the taxpayer the opportunity of counter-proving his transaction. Following question, what is the proportionality of the burden of proof? The court said that the taxpayer should prove its commercial justification without being subject to undue administrative constraints. But the court didn't say what are these undue administrative constraints. Is the court referring to the EU documentation requirements? The court didn't justify that, didn't mention that. And of course the risk is that without any details of what undue administrative constraint means, the countries would require the taxpayer so many information in order to justify the economic nature of their transaction that obviously the ability of the taxpayer would be zero to counterprove the transaction, to counterprove the fact that the transaction is not fictitious. Finally, who has to carry the burden of proof? The court said the taxpayer has to have the right always to counterprove the presumption of the tax authorities. But they never said how does that work. In some countries, the tax authorities go to the taxpayer, they assess the tax base, and they say why they assess the tax base. So they need to provide evidence, and this is the so-called primary burden of proof. And then the taxpayer, based on what the court said, should have the secondary burden of proof, the ability of counterproving the assumption of the tax authorities. But in some other countries, the tax authorities assess the tax base of the taxpayer without giving any reason. The taxpayer has to prove that he has been he has some economic justifications for his transaction. But then the court didn't say if the tax authorities in that case should have the secondary burden of proof. And of course, this may have relevance. And finally, the last question that may be a consequence of this case regard the adjustments to the tax base. The court said that the corrective measure of the tax authorities cannot go behind what is the arm's length amount. So it seems from one side that the court is referring to the primary adjustments to the tax base, and the tax authorities cannot assess the tax base of the taxpayer more than the arm's length principle. But again, can the taxpayer, from the other hand, use a non-arm's length price in order to, if he's able to justify the economic reasoning? Obviously, if we take only the second proportionality test into account, it seems that the court is referring only to the arm's length principle. But if we take into account both proportionality tests together, it seems that the court in the second proportionality test is just refraining tax authorities by overreacting to a non-arm's length amount and assessing the tax base of the taxpayer for more than the arm's length price, but is not saying from the other side that if the taxpayer has a non-arm's length amount, it cannot still justify it with economic reasons. And this argument may be also find some other basis in the fact that Advocate General Cocotte, to this case, was relying all the time on the arm's length principle. And the court instead did not speak of arm's length principle, but it spoke about commercial justification. So these are all questions that may be arisen by this case, and of course, this case will have important impacts on the transfer pricing rules of each member state. Now we know that that the member state should have some limits to their transfer pricing rules, but from the other side, as we have seen, it has opened a lot of other questions, and still we think that we will need clarification about these questions, and more court cases on transfer pricing might be arisen in front of the ECJ. Thank you.
Marina, the floor is yours.
Bueno, buenos días, me toca a mí, espero que me entendáis. Hablo en español, o sea que va a ser más fácil. Primero de todo, bueno, agradecer a Pedro Herrera haberme invitado a este seminario y la grata compañía de Raffaele. Y nada, voy a empezar la presentación. Yo también hablo del mismo caso, del SGI, pero desde otro enfoque. Yo me he centrado más en el principio de proporcionalidad y analizar la sentencia, básicamente, pero a partir de la teoría de un filósofo del derecho que es Robert Alexi. Como ha comentado Raffaele, el caso de la estructura es la siguiente. O sea, tenemos una compañía belga, que es SGI, que tiene una filial en Francia y a la vez ella tiene una participación del 34%, o sea, la sociedad de Luxemburgo la tiene sobre ella. Y el problema reside en las transacciones que se hacen. O sea, hay un préstamo de la sociedad belga a la francesa sin que en ese momento pues tuviera necesidades económicas y por lo tanto no pudiera justificar en la transferencia del préstamo, además un interés cero, y por otra parte se produce una retribución por el cargo de administración de 8.000 euros que el tribunal a la vez considera que es excesivo y que no tiene ninguna justificación porque ya se estaban pagando las retribuciones por otro lado. Con lo cual, a partir de la problemática, el tribunal belga pensó, vale, o sea, aplicamos una normativa belga que es la siguiente. O sea, cuando una sociedad belga tiene una filial, por ejemplo en España, en otro país, y se produce una transacción que sea anormal o benévola, una ventaja normal o benévola, esta transacción deberá tributar por el código belga. No obstante, si se da el mismo caso, pero dentro del mismo país, ¿qué pasa? Pues que no tributa. Entonces tenemos un problema. Y el tribunal belga dijo, ostras, tal vez se está vulnerando la libertad de establecimiento en este caso. Por lo tanto, pues nada, vamos a llamar al ECJ y vamos a ver qué es lo que responde ante tal problemática. Y la respuesta del tribunal pues dijo que, mira, la normativa belga no se opone a la libertad de establecimiento en estos casos, aunque haya una tributación cuando está en el exterior, en un país dentro de la Unión Europea, pero siendo el mismo caso en Bélgica mismo, pues no tributa. Pero dijo siempre y cuando se aplique esta normativa con proporcionalidad, es decir, justo para alcanzar los objetivos que persigue la normativa, pero nada más, no es extralimitarse. Con lo cual, si somos puntillosos y analizamos toda la sentencia, vemos que hay un apartado que el tribunal reconoce que se está vulnerando la libertad de establecimiento por parte de la normativa belga y lo reconoce abiertamente. Y dice que cuando se produce una diferencia de trato fiscal de este calibre, cuando tienes una filial en el extranjero, pues lo que puede provocar es que hay una doble imposición, en este caso porque se puede tanto gravar la transacción benévola en el tercer país o en Bélgica, y esta distinción, pues aparte de la doble imposición, puede conllevar pues que Bélgica se plantee, la sociedad belga, pues trasladar o montar una filial dentro de la propia Unión Europea, y el tribunal lo reconoce ampliamente. No obstante, justifica la restricción de la libertad de establecimiento para, primero, garantizar el reparto equilibrado, la potestad tributaria del Estado belga, y segundo, para guardar las espaldas por temor de evasión fiscal o de elusión fiscal. Y mientras la normativa belga persiga su objetivo, por otra parte, puede tener los efectos colaterales de utilizarse como una normativa antiabuso belga, con lo cual, partiendo de estas razones, permite que se vulnere la libertad de establecimiento por una normativa interna de un Estado, cuando, en principio, las libertades fundamentales, que están en el tope de la pirámide de Kelsen, no deberían vulnerarse ni restringirse bajo ningún concepto. Pero si analizamos el concepto de proporcionalidad de Robert Alexy, como él lo entiende, la proporcionalidad pues tiene que enmarcar y controlar precisamente estos derechos y libertades, con lo cual es un principio limitador de principios, según entiende él. Y la misión de este control de las libertades fundamentales es la relación que existe entre los fines y los medios. Y él lo hace a partir de tres criterios, que es la necesidad, la idoneidad y la proporcionalidad en sentido estricto. Porque él considera que un medio debe ser estrictamente necesario e idóneo, y debe ser el más moderado para poder lograr un fin, sin extralimitarse, ni de más ni de menos, lo proporcional, lo justo. Con lo cual, si analizamos estos tres criterios, en el caso de SGI, la idoneidad, ¿para qué? Para el mantenimiento del reparto de la potestad tributaria, porque la normativa belga, al gravar las transferencias benévolas en la Unión Europea, pero no dentro del Estado belga, lo que hace es proteger y garantizarle al Estado belga que va a recibir su parte del pastel. Y en este caso, lo que considera el tribunal es que no había ninguna justificación ni ningún criterio económico que justificara el crédito que le concede la filial francesa, ni por otra parte las cantidades que remite como remuneraciones en Luxemburgo, y que si no se gravaran, ¿qué pasaría? Pues que se le estarían escapando dinero que podía ingresar en su caja y en su hacienda para el bien y la contribución con el público, o sea, con los ciudadanos. Y lo que él considera es lo mismo que ya se había dicho en otras sentencias, en la sentencia OIAA, que es los noruegos, los suecos utilizan estos nombres, y que la normativa le permitirá al Estado pues ejercer su potestad tributaria. La necesidad. ¿Por qué se necesita una norma que limite esta libertad de establecimiento? Pues para precisamente cumplir con el mandato de la Unión Europea, que lo decía ya en su normativa de 2007, que es la necesidad de frenar tanto la evasión fiscal como la elusión. Y, por lo tanto, las libertades fundamentales, bajo esta máxima, se pueden restringir. Con lo cual, el objetivo de la normativa belga no es directamente el de actuar como una norma antiabuso, pero como un efecto colateral que tiene es pues le permite que siga su camino y que, por tanto, la libertad de establecimiento sea restringida. Y, por lo tanto, si se produce una ventaja fiscal en un Estado miembro, pues, ¿qué pasa? En principio, la fiscalidad directa no es parte de la Unión Europea, no tiene control sobre la misma, con lo cual cada Estado es libre de legislar como le dé la gana, más o menos, evidentemente. Y por lo tanto, por el mero hecho de que una compañía establezca un establecimiento secundario en otra parte, como ya nos decía la sentencia de Cadbury Schweppes, no debe de haber una presunción de que diga, si la manda ahí en Luxemburgo, que hay una fiscalidad más beneficiosa, o en Irlanda tal, ya tenemos que presuponer que lo que intenta hacer es que la evasión de impuestos, o eludir o utilizar, y el tribunal ya lo dijo, pues no, o sea, no tenemos que partir de esta presunción. Pero por otra parte, si analizamos caso a caso y vemos que hay un montaje puramente artificial y que la finalidad de tal operación sí que es la elusión fiscal, pues entonces pues es proporcionado que una normativa de un Estado pues pueda restringir una libertad fundamental porque actúa como una medida antiabuso, que también se menciona en la sentencia Cadbury Schweppes. ¿Y qué es la proporcionalidad en sentido estricto, el último criterio de Alexis? Pues es básicamente una relación de precedencia condicionada entre dos principios que colisionan, que en este caso, ¿cuál sería? Pues la potestad tributaria del Estado belga a, en este caso, gravar la transacción que se hizo a Luxemburgo y a Francia, pero por otra parte está la libertad de establecimiento, que también asoma ahí su manita y quiere también su parte. Que lo que lleva a cabo luego Alexis, pues hay dos principios y a la vez utiliza tres elementos para poder decidir cuál de las dos libertades tiene preferencia en cada caso concreto. Y lo que hace es les atribuye un peso y una argumentación, y la balanza luego se inclina dependiendo de qué pasaría si una de las dos normativas no se dejara de aplicar y se aplicara la otra. O sea, cuáles serían las pérdidas más graves y qué sería lo más beneficioso. En este caso, pues, ¿qué pasa si el Estado belga deja de aplicar su normativa y se producen todo este tipo de transacciones y de montajes? Pues que el Estado belga deja de ingresar, como hemos dicho, en su caja. Por lo tanto, menos ingresos, menos contribuciones para los ciudadanos. Y puede permitir que se le escapen montajes artificiales y que haya casos de evasión fiscal claros. ¿Qué pasa si aplicamos la normativa, ¿qué pasa si se aplica el otro principio? Pues que si aplicamos la normativa belga, estamos vigilando que no se produzcan evasiones fiscales y que por lo tanto pues todo cuadre y haya un guardia que se encargue de proteger los intereses del Estado. Y en este caso el tribunal consideró que era mucho mejor que se restringieran las libertades fundamentales y en este caso la libertad de establecimiento a favor del control de las prácticas abusivas. ¿Qué pasa con la normativa española? Hasta 2006, pues cada cual hacía lo que le daba la gana, hasta que se dieron más o menos cuenta de que era una política bastante agresiva, sobre todo respecto de las obligaciones de documentación que Raffaele ha hablado, y con la ley antifraude, lo que intentaron hacer es suavizar estas medidas. No obstante, no estaban todavía acordes con los criterios que mandaba la Unión Europea y tenían que adaptarse un poco más a los criterios de las directrices. Y esto vino ya en 2010 con los dos reales decretos para combatir la crisis económica. En el primero de ellos se suavizaron las medidas y en el segundo ya terminaron de rematarlo y se aseguraron de que los criterios de documentación no fueran tan exigentes, con lo cual lo que pasó fue que eximieron de tales obligaciones de documentación a los que podríamos llamar la pequeña o la mediana empresa, que su base imponible no superara los 8 millones de euros y que las operaciones vinculadas que se dieran tampoco superaran la cantidad de 100.000 euros. Luego, otro tema que es interesante de comentar sobre los precios de transferencia, he considerado que es la base imponible común, que está todavía pendiente en el aire, pero va cogiendo forma poco a poco. La CCTB, que son sus siglas en inglés, Common Corporate Tax Base, intenta solucionar los problemas en el caso de transacciones intragrupo y parece que lo consigue, porque hasta ahora, lo que he dicho antes, la falta de armonización de la imposición directa pues hace que haya casos de doble imposición, de no imposición y que influya en la localización tanto de los establecimientos como de los beneficios, que eran los casos estos de doble imposición que viene analizando el tribunal, este caso, Cadbury Schweppes, el Income Law, etcétera. Pues muchos de ellos tienen relación con estos temas. Y lo que intenta hacer esta normativa es que las operaciones intragrupo, sobre todo de crédito o de capital, no formen parte de la base consolidada. Al no formar parte, pues ¿qué pasa? Que los precios de transferencia, pues cuando se produce una transferencia de las características del caso, del SGI, pues no formarían parte de ella, no se fiscalicen y con lo cual pues ya no habría problemas ni con las normas de subcapitalización ni la propia norma de precios de transferencia porque ya no cuenta. La base imponible lo que hace es se basa en unos factores en los cuales estas transacciones intragrupo dentro de la Unión Europea no cuenten y así se solucionan toda esta problemática que nos ha traído de cabeza. Y finalmente quería terminar resumiendo un poco el ambiente en el que estamos ahora respecto a las políticas de combate a la evasión y a la elusión fiscal, que cada vez más la OECD, con la creación del Global Forum, está intentando crear unos criterios y unos mecanismos globales para intentar evitar estas prácticas con los convenios FATCA, los convenios Rubik. Y lo que pasa es que la internacionalización de los instrumentos financieros, todas las transacciones, cada vez estamos en un mundo mucho más globalizado que si no nos ponemos de acuerdo, pues si cada país tiene su propia normativa para evitar estas medidas, pues siempre habrá agujeros que no podamos tapar. Y lo que están intentando hacer ahora es que haya un intercambio de información entre los países de forma abierta. La Unión Europea ahora mismo ha firmado un acuerdo que es similar al FATCA, que es un acuerdo americano de intercambio de información, y hay varios países, entre ellos Francia, Gran Bretaña, Alemania, Italia e España, lo han firmado con Estados Unidos. Pero el problema también de tanta práctica y tanta prevención para la evasión fiscal es que no nos olvidemos de los derechos de los contribuyentes, en este caso el derecho a la privacidad. Y yo creo que se tiene que ir un poco con cuidado porque detrás de un evasor fiscal también hay un ciudadano con sus derechos y que también se tienen que proteger y también están ahí, aunque en este caso el tribunal se los haya saltado. Pero yo creo que se tiene que ir con cuidado en este sentido y no olvidarnos de esto, que todos somos ciudadanos y que debemos pues también proteger nuestra intimidad en este sentido. Y nada, pues hasta aquí, gracias por su atención y nada, estamos abiertos, Raffaele y yo, a preguntas.
Many thanks, Raffaele and Marina, for your inspiring. Many thanks, Raffaele and Marina, for your inspiring presentations. And now we have some time for questions. Do you have any question? Por favor. Aitor, pero espera un momento que te dejemos el micrófono. Mercedes o Jessica, podéis. Bueno, tenemos aquí ascensores.
La planteo... ¿Sí? Ah, vale. La planteo en inglés, ¿no? Mejor o... Sí, bueno, es a los dos en realidad.
Yeah, I have a couple of questions for both speakers. The first one is related with the whole artificial arrangement criterion, because I don't see that it is clear the relationship here between valid commercial reasons, the wholly artificial criterion, and indeed the arm's length principle. So could you explain more about that? And the second question, it's regards the double taxation conventions, and well, it is which is the significance of this EU the ECJ criterion regarding the application of a DDC, and the Article 9 that contains the arm's length principle, because I think that the concepts are not the same in both levels. So, thank you.
So the first question relates to artificial arrangements, the economic reasoning, and the arm's length principle. So the second justification that the court found was if these rules were preventing artificial arrangements. If these rules were justifiable as anti-avoidance rules or not. And the second justification was if these rules were protecting the balanced allocation of taxing powers of the countries. Okay, so I think that your question refers to the second, which is the anti-abundance nature of transfer pricing rules. The court said that you can have transfer pricing rules in your legislation, you can discriminate residents between non-residents, but you have to give the taxpayer the opportunity to show that the transaction that is doing is not an artificial arrangement. Because the court said under Cadbury-Schweppes, since Cadbury-Schweppes, that in Europe, whenever you have some rules that discriminate, some anti-avoidance rules that discriminate countries, European countries, European cross-border transaction with national transaction, you always have to give the taxpayer the opportunity of proving that that transaction that is performing is not an artificial arrangement, is not a fictitious transaction. So in this case, in SGI case, the court defined how to give the taxpayer the opportunity of showing that the transaction is not artificial. And the court said that in order to give the taxpayer this opportunity, you have to give him the opportunity of showing what are the commercial reasoning of the transaction. In other words, if the taxpayer is able to show that he has commercial reasoning for making the transaction, as we have said in the financing example, the parent company has commercial reasoning for financing its subsidiary. Otherwise, it would just simply close the subsidiary if it doesn't believe in the future business profit making of the subsidiary. Then the taxpayer should be able not to be discriminated. So the taxpayer should be able to show the transaction as commercial reasoning. Now, my question is, are we talking about commercial reasoning here, or are we talking about arm's length principle? Because as we've seen, arm's length principle are two different things than commercial reasoning. And obviously, if we look at this decision of the court, it seems that the court is talking about commercial reasoning. The court speaks about the arm's length principle, but speaks only when it says that the tax authorities cannot make an adjustment that is bigger, that is more, that is worse than what would be the arm's length price. In other words, if you have a non-arm's length transaction, then the tax authorities can come to you and say, look, there are no commercial reasoning for these transactions. You don't show me any commercial reasoning, so I will make an adjustment. But the adjustment that the tax authorities can make cannot go behind what is the arm's length amount. But from the other side, the court still says that the taxpayer can be able to justify the transaction under commercial reasoning. So in my view, in that example that we have seen before, the court is saying that since parent company is able to show the commercial reasoning of the financing transaction, the tax authorities of state B, the one receiving the financial loan, should accept the fact that that transaction is real as commercial reasoning, and even though even if the price of the interest doesn't look to be arm's length in their view, they should accept a price that is not arm's length because it has economical justification. So in that case, it would avoid double taxation, which is a big issue in Europe and which still don't have any solution for it apart from the arbitration convention. So this is, to me, the relationship between artificial arrangement, economic justification, and arm's length principle that I see in this case. Regarding the double tax convention and Article 9, the Advocate General Cocotte started his analysis of the arm's length principle from Article 9 of the double tax convention. The court instead, in their decision, did not start their reasoning from the arm's length principle under Article 9 of the OECD model convention. I would say that, as Advocate General Cocotte said in its analysis, the European countries take into account whenever they speak about arm's length principle, Article 9 of the OECD model, because that's the model and that's the article that they have in all their double tax treaties in Europe. So the definition of arm's length principle should derive from an international perspective, of course, from Article 9 of the OECD. And that's also the same in the UN model. So we can say that Article 9 of the OECD, whenever we are dealing with international transactions, at least in Europe, is the basis for the definition of the arm's length principle. I don't know if it's what you were referring to or not.
Perhaps Marina can answer you too, and then we come back to...
Respecto a la primera pregunta, por lo que he entendido es que el caso principalmente es lo que ha dicho Raffaele. Pasa por alto si hay el arm's length principle, o sea, si se da el criterio, no me sale ahora en castellano. Sí. Y lo que hace es simplemente analizar si en el caso, en la transferencia benévola, pues si hay razones económicas válidas para hacerlas o no. Y se centra básicamente en eso y te justifica la respuesta en base a si hay o no hay. Y lo que dicen es que como las cuentas de la sociedad francesa a la que se transmite el crédito pues están bien, no hay necesidad de por qué hacer esta transacción a un interés cero. Y justifíqueme usted por qué lo hace cuando no tiene pérdidas, no tiene problemas, porque le da un crédito. Para eludir tal vez unos beneficios que usted ha obtenido en Bélgica, pasarlos a Francia y así tributar por un porcentaje más bajo. Y claro, a la sociedad no le quedó pues ninguna justificación porque no había, era un montaje artificial. Lo mismo que pasaba mandando a Luxemburgo las retribuciones. No había ningún tipo de justificación. Y el tribunal básicamente pues se basó en esta razón para descartar. punto. No creo que haya más, y creo que además es clara el montaje que hicieron, o sea, que el tribunal tenía toda la razón.
¿Preguntar algo más? Tenemos que esperar a que vuelva el micrófono. Lo siento.
Yeah, referring to the comments that Raffaele Petruzzi stated regarding the arm's length principle both in Article 9 and the valid economic reasons. My question is, could a state make an arm's length adjustment based on Article 9 and then said to the taxpayer, I don't care about commercial reasons because this is not the criterion that it is stated on the DTC, regardless of we can take the example of two EU members that in theory should respect the criteria of the ECJ. So my question was regarding this, and yeah, I have another question indeed. I don't know, because I don't really agree on that the wholly artificial arrangement is to be measured with a valid commercial reasons criterion, because I think that's two different, those are two different concepts also, because there's nothing, I think here in this case, there's nothing artificial here from a private law concept, and indeed, I don't see the justification to not to permit the taxpayer to deduct the retributions, the management fees of Coordinan. So could you extend your explanation on that? Thank you.
Thank you for clarifying your question. Regarding the relationship, again, between artificial arrangement and the commercial justification, in paragraph 71 of the judgment, I don't know if you have it in front of you, this is the critical point that we are talking about here. And the court said, here is talking about the first proportionality test, and say national legislation which provides for a consideration of objective and verifiable elements in order to determine whether a transaction represents an artificial arrangement entered into for tax reasons is to be regarded as not going beyond what is necessary, so it is proportional basically. If, then it says, the taxpayer is given an opportunity, without being subject to undue administrative constraints, to provide evidence of any commercial justification. So, to me, it seems that the court here is saying that you have to give the taxpayer the opportunity of showing that it is not an artificial arrangement. And then he's saying how? He's saying by providing evidence of any commercial justification of the transaction. So I agree that the two concepts are not the same. I'm not saying that artificial arrangement and commercial justification are the same concept. I'm saying that the court is here trying to tell to the national legislator how you should give the opportunity to the taxpayer to show that it's not doing an artificial arrangement. The how is by giving him the opportunity of showing the commercial justification of the transaction. Is it clear? It is more clear. I don't know if I made clear what I want to say. And regarding the second point, well, you said that Article 9 is one thing, arm's length principle is one thing, the value economic reason is another thing, and what if the tax authorities of one country says, look, what I have in my double tax convention is Article 9, what I have is the arm's length principle, so I don't care if you provide me of any economic justification, because what is in my national rules and what is in the double tax treaty, which most of countries implement in their national rules, so it is by itself a national rule as well. There is Article 9. There is not, as you have said, any mentioning of the economic justification. But here, we're not talking of national rules per se, but we are talking about the relation of the national rules with other countries. We are talking about discrimination within Europe. And we are saying that we will treat differently cross-border transactions than national transactions. And this is what is the ECJ caring of. And it's saying, look, either you apply your transfer pricing rules in the same way with national companies, then I'm fine, because you apply the arm's length principle with national companies and you apply the arm's length principle with foreign companies, and I'm fine. But as far as you apply your transfer pricing rules in a different way with national companies and international companies, in my opinion, you are discriminating. So the solution to such discrimination is having proportional rules. And how these rules would be proportional is by giving the opportunity to the taxpayer to show the economic justification. The court says that this is something that the rules should have. And the court said the same in the FinCap law, in the UK case on the FinCap rules, and it says that you can have FinCap rules that discriminate national with non-national, residents with non-resident, but you have to give the opportunity to the taxpayer to show that it's not doing an artificial arrangement. How? With economic justification. So I don't care if your FinCap rules are based on Article 9. I don't care if your arm's length principle is based on Article 9. You should always, if you want to discriminate, give the opportunity to the taxpayer to show the economic justification. This is what is the court saying. And in this case, the judgment of the court would prevail over the national legislation of the country. I don't know if it's clear, the point. Okay,
thank you very much for this very clarifying answer. Do you have any more questions? Okay, then I would like to pose you a question, because here the court brings up two justifications: the balanced allocation of taxing powers and combating tax avoidance. Do you think that the first one, this balanced allocation of taxing powers, has as a consequence watering down the proportionality control?
Okay. First, in order to be clear again, the court has dealt with the problem of the arm's length principle in the previous FinCap law. It spoke also in the long course, but really it dedicated only one little paragraph. And in that case, in FinCap law, the court said that you can have FinCap rules discriminating as far they are justifiable just by tax avoidance. In this case, instead, the court introduced another justification, which is the balanced allocation of taxing power, and they say that both justifications should be taken together. The reason for the court for taking such justification is clear. Belgium has 33% of tax rate, and France has 33.33. So if the court would have said these rules are justified by tax avoidance, then the taxpayer would say, which tax avoidance? I'm not avoiding any taxes. I'm moving tax base from one country to another that has the same tax rate. So unless there is a situation of loss of setting, maybe, then there are no tax avoidance rules, no tax avoidance justification. So this is why the court introduces the balance allocation of taxing powers, which is, again, a justification that is way different than tax avoidance in the consequences that it gives. With the tax avoidance, we are giving more importance on the subjective intention of the taxpayer. We are looking at what the taxpayer is planning to do in his transaction, and we are looking at what he did, in fact. What he did is not tax avoidance. So basically, if the taxpayer has economic justification for it, he should be able to counteract the adjustment of the tax base. But the balance allocation of taxing power is a different concept. It says that all countries should have their own fair proportion of tax base. In this case, Belgium is losing a proportion of tax base. I'm not seeing the transaction internationally, but I see the transaction from a single country point of view, and I see that Belgium is losing tax base in favor of France. So the court says that these transfer pricing rules are justified by both the tax avoidance and the balance allocation of taxing power. And it was important that the court specified that, because otherwise, all the time that the taxpayer is not avoiding any taxation internationally, globally, then the taxpayer would have say, look, this rule, these anti-avoidance rules, these transfer pricing rules are not compliant with EU law. So there are two different justifications, really, really far away from each other. It is important that the court mention both of them, but still, the question that raises is which one is more important. Is it tax avoidance more important? Therefore, giving the taxpayer intentions more importance? Or is the balance allocation of taxing power more important? Therefore, giving the rights of the country to have its own portion of fair tax base more importance? The court didn't say which one it is. The court made clear that is a step further after the think-up law. It made clear that also the balance allocation taxing power should be taken into account, but we still don't know if arm's length principle or economic justification should be the one prevailing. And of course, in my view, it seems that the economic justifications are the one prevailing, but obviously there are arguments for saying that the arm's length principle is the one prevailing. Last thing is that, as I was mentioning during the presentation, Advocate General Cocotte, when he was analyzing this case, he says that economic reality and economic justification mean arm's length principle. And this is something that obviously, as we have seen in the example, it is not true. It is important that in the previous case on arm's length principle, think-up law, Advocate General was referring to the economic justification. It was not referring to the arm's length principle, because the think-up rules of UK were based on the arm's length principle. That's why it was about arm's length principle, even if it was not about transfer pricing. And the court said the same thing of the Advocate General, said that arm's length principle and economic justifications are different things, and economic justifications are the valid one. In this case, instead, the Advocate General said arm's length principle is the same as the economic justification, but then the court said, no, the economic justifications are the one that should be taken into account. So in my opinion, the court is taking the distance from what Advocate General is saying, contrary to what think-up law said, that they were the same thing. Economic justification were the important ones.
Thank you very much. Let's give the microphone to Florencia Gaido.
I was... ¿Sí? Okay, pero se oye. I was just thinking, Raffaele, when you were explaining just this, about the disregard concept that we have in the guidelines, that form, of course, also part of the arm's length principle. If we look at the case here, it seems that they are actually disregarding the transaction between the intercompany transactions between the related entities. So if they say, okay, this is not a loan, these interests are not deductible, for instance, this is just more participation of the parent company and the subsidiary's equity, they are disregarding the transaction because a third-party bank would not give money to an entity that is in a loss-making situation. Isn't that arm's length principle? For us, as practitioners, it is. And I think that, for instance, for any court in Spain right now, where we have several cases that are similar to this, that would be also the application of the arm's length principle.
Again, as I was saying before, I'm also a practitioner, so I know what the arm's length principle is. And as I was saying before, there is a big difference between the arm's length principle and the economic reality. And again, if the national rules say that you should use the arm's length principle, you should, under the national rules. But the ECJ is not talking about national rules, it's talking about discrimination. And if you treat different same situations in different ways, as it is in this case, then the court is going to tell you how you can do it, how you can treat different same situations in different ways. And the way that you can do it is giving the taxpayer this opportunity, the economic justification opportunity. And of course, you can have anti-avoidance rules as much as you want in your national law, arm's length, think up, CFC, but you always have to comply from the other side with the European Court of Justice, if you are a European member state. So the European Court of Justice is going behind what is the arm's length price, what is the arm's length principle.
Thank you. I have a last question for Marina. Me ha parecido muy interesante la aplicación al derecho tributario de las teorías de Alexi, y la pregunta es la siguiente. Una vez que llegamos al último nivel de control, porque en realidad esta aplicación de estas teorías tampoco se aleja tanto de la práctica del Tribunal de Justicia, pero una vez que llegamos al último nivel de control, proporcionalidad en sentido estricto, poner un platillo de la balanza el fraude fiscal, en el otro platillo de la balanza el mercado interior, ¿no piensas que estamos ya ante un nivel de decisión que es puramente político y que como mucho los criterios que da Alexi pues son unos criterios de buena decisión política, pero no mucho más? ¿O qué te parece?
Bueno, lo que yo creo es que Alexi se basa en un principio como si estuviéramos en un mundo perfecto y que todo el mundo tuviera un criterio de buena gobernanza que fuera justo en el sentido de la justicia de Ulpiano, de justicia es aquello proporcional, darle a cada uno lo que se merece. Y partiendo de este principio, que es muy bonito, muy utópico, pues realiza su teoría. Y el principio de proporcionalidad en sentido estricto queda un poco colgado en el aire, porque son argumentos que les puedes dar la carga de peso que tú creas en conveniencia en cada caso. Y claro, eso yo creo que es muy subjetivo. Y por lo tanto, si pones lo que has dicho tú, el platillo del fraude fiscal a un lado y las libertades fundamentales al otro lado, pues si en este momento que estamos en que el contexto internacional de crisis económica, que ahora todo el mundo, todos los organismos están sacando normativas antiabuso y mirando con pelos y señales, pues harán lo que sea para intentar que el fraude fiscal y que tal vez algunos derechos fundamentales de los contribuyentes que están un poquito en la otra balanza, pues se ven afectados. O sea, pero es subjetivo, yo creo, totalmente.
Pues muchísimas gracias a nuestros ponentes, gracias a todos ustedes por asistir. Les invitamos al próximo seminario, que se anunciaremos por correo, se celebrará aquí también en este instituto a cargo de un joven investigador de la Wirtschaftsuniversität de Viena. Muchas gracias y les pido un último aplauso para nuestros ponentes.